Mr. Millan, and then we have is government counsel hearing us okay?
Yes, sir.
All right, very good. Mr. Millan?
Good morning, Your Honor.
I'm sorry, so government counsel, your name is it Beier or Beier?
It's Beier, correct.
Beier, okay. Mr. Beier, if at any time the audio cuts out or you can't hear or you're having any kind of difficulty, we will not consider it rude if you interrupt and just say that you're having some kind of an issue.
Thank you very much.
Okay, Mr. Millan.
Good morning. May it please the court. I represent Mr. Ochoa-Salgado. This case comes back to the court from a previous remand from this court to the Board of Immigration Appeals. Specifically, this case was remanded to the Board of Immigration Appeals for them to consider the holding in Hinkle, United States versus Hinkle, and Mathis versus the United States. That remand was then taken up by the Board of Immigration Appeals, which then issued two decisions. The first decision that they issued, in that decision they considered the Hinkle decision as issued by this court and agreed that my client had not been convicted of an aggravated felony. In the second decision they issued, after they vacated that one, which was issued in June of 2019, the Court of Appeals determined by using Third Circuit and Sixth Circuit President, Second Circuit President and Sixth Circuit President, that my client was in fact convicted of an ag felony. The question today before the court is simple. The question is whether or not my client was in fact convicted of an ag felony based on the elements under which he was convicted. In Mathis, the Supreme Court unequivocally reaffirmed that a sentencing judge may only look to the elements of the crime of conviction and not to the defendant's conduct when determining whether a prior conviction falls within the sentencing enhancement provision of the Armed Career Criminal Act. In essence, you have to look at what the statute says, not what my client did.
What specific conviction documents do you contend the board wrongfully used below?
I believe that the board looked at the transcript of the plea, Judge Parker. They looked at the transcript of the plea, which I provided.
Mr. Millan,
To the immigration court.
Yeah, you start your answer over again. You need to stand right in the middle when you're speaking. I understand that you can step aside so you can hear. That's okay. But
Yes, Your Honor, I apologize.
that's all right.
I provided the plea colloquy to the immigration judge, outlining exactly what the plea was about. However, that's not the inquiry here. The inquiry is not what he actually did, but what the statute calls for. But I did provide that, and it's in the record of proceedings, Your Honor. Now, the court in Mathis empathetically reaffirmed that the sentencing judge should only use the categorical approach to look only to the elements of the conviction to ascertain whether the crime of conviction falls within a federal statute. The court stated the judge may not look to the underlying record of conviction or facts to parse whether the means of fulfilling the elements would cause the crime to fall within the federal statute. Hinckley took the decision in Mathis and came up with a rationale very similar to it. The interesting thing about the Hinkle decision is that Mr. Hinkle was convicted under the same statute that my client was prosecuted under in the state of Texas for delivery. And Hinkle applied the process set forth in Mathis to a case in which the court addressed whether conviction under 48.1212 of the Health and Safety Code of the state of Texas was a controlled substance violation as defined by 42B12 of the Federal Career Offender Guideline provision. Now, the Hinkle court determined that delivery was an element of the statute and that there was various ways of satisfying the element of delivery as defined in section 41.0028. Were not separate elements, but mere factual means of satisfying the element. The court in Hinkle then compared the element of delivery in the Texas Health Safety Code to the definition of a controlled substance violation in the Federal Career Offenders Guideline. After they did that, they determined since the statute sections 48.1112 and 481.002 encompass an offer to sell, and the guidelines do not. The court found that a crime of conviction was broader than the federal definition of a controlled substance.
The court found or the government conceded?
I believe the court found, Your Honor. That's what I wrote in my brief. The court offered to sell and the guidelines do not. The court found that the crime of conviction was broader than the federal definition of a controlled substance in the career offender guidelines. Thus, the defendant can violate the statute without committing a controlled substance offense covered in the federal statute. Now, the application of Mathis and Hinkle make it clear, Your Honor, that the BIA erred in determining that my client committed an aggravated felony, because they literally looked not to the elements of the conviction, but looked at the underlying conduct, which if you look at the decision rendered by the immigration judge, that's exactly what she concentrates on. Had they not concentrated on that, then it's not an aggravated felony. As an aside, I wanted to point to the court that when the immigration proceedings started commencing this case, my client was initially charged as an aggravated felon. That was one of the charges that they initially made. And then the government moved to withdraw it. And
Counsel, would you care to respond to the government's argument? Would you respond to the government's argument that even if the charging documents are not considered, the offense itself is categorically an aggravated felony as a drug trafficking crime?
No, Your Honor, because it's much broader. My offense, the elements of the offense under which my client was convicted is much broader than the federal definition.
Because of the offer to sell?
Correct, Your Honor, because of the offer to sell provision.
Now, do you dispute that under state cases like Douglas v. State and Garber v. State, a bald, standing alone offer to sell drugs does not support a conviction for delivery of drugs under section 481.112?
I would agree with that, Your Honor.
You do agree that a bald offer standing alone does not support a conviction?
I would agree with that, Your Honor.
Okay. So do you agree that under those state cases, to get a conviction under 481.112 of delivery of drugs by an offer to sell, the state must also prove an intent to complete the sale?
I would agree with that, Your Honor.
So if that is required, what more would have to be required for the state crime to match the federal crime that triggers an aggravated felony?
Actual delivery, Your Honor. The actual transfer of the drugs. An offer to sell is not enough. The actual transfer of the narcotics.
Why wouldn't that be an attempt?
I'm sorry, Your Honor.
Why wouldn't that be an attempt under the CSI?
It could be deemed an attempt, Your Honor, but again, in the federal statute, the statute is very specific about what constitutes drug trafficking. And drug trafficking is not constituted by an offer to sell.
Well, as you know, much of the case law uses some of the sentencing guideline cases as a parallel, and we can consider those binding under these circumstances. And as you know, the commentary to guideline 2L1.1 was changed to include offer to sell. There was a specific change there. So that would undermine any of our case law, it seems to me, that was decided before then.
It might, Your Honor, but I think you also have to look at the holding that this court held, the holding that this court determined in Hinkle, and look at the litany of cases this circuit has had in relation to what encompasses a drug trafficking offense when it's broader than when the federal statute is not as broad as the state criminal statute. I don't think it invalidates everything this court has decided.
So in your view, the difference that makes the state crime broader than the federal crime is the state crime does not require an actual transfer of drugs?
No, it does not. It requires merely an offer to sell, and that's enough. That will get you convicted under the provisions of the statute. An offer to sell is enough, Your Honor.
Have you looked at the federal crimes definition of distribution to include an attempted transfer?
I've looked at it, yes, Your Honor, but an offer to sell is not an attempted distribution. An offer to sell, in my opinion, is not a transfer, nor is it an attempted to be able to sell something. There is no attempt. An offer is very different. I can offer you something for sale, and then I can attempt to sell it to you. There are two different things, Your Honor.
Have you looked at the state cases indicating that to complete the state crime by an offer to sell, the defendant must also intend to complete the sale?
I have looked at those cases, Your Honor.
How is that different than an attempted sale?
Well, in my opinion, it's different because, again, there's no actual transfer of narcotics. And an offer to sell is just that, an offer to sell. But without an attempt to actually deliver those drugs, I don't see how I can rise to the level of the federal statute.
So your contention is the state crime does not require the conduct of a step in furtherance of this offer.
I agree.
And your contention is the federal crime, the attempt, does require a step in furtherance.
Yes. Now, going back to the immigration case, Your Honor, when the immigration case started, we were charged initially under the aggravated felony provision and charged as a person who has been convicted of an aggravated felony. At one of the initial masters, the government then chose to go ahead and withdraw that particular charge because under the holding of USA versus Vasquez Martinez, they could not make the cause or make the determination that my client had in fact been convicted of an aggravated felony, as outlined in the Immigration Act. They withdrew it.
I'm sorry, I want to go back to the previous discussion. Can you give me a hypothetical fact pattern where somebody would violate one but not the other?
This would be my fact pattern, Your Honor. You could violate the Controlled Substances Act by by transporting drugs, for instance. Well, transporting drugs in the state of Texas is also identical.
No, but I want to go to I apologize. I want to go to the offer to, let's not have an actual delivery. So we're talking about offer to sell, which I think sounds to me like attempt, but you're telling me they're different, and I want to give you a chance to explore that. Give me a fact pattern where it's one but not the other. It's an offer to sell, but it's not an attempt.
I'm sorry, Your Honor?
Where you have an offer to sell, but not an attempt.
A person may make an offer to sell, Your Honor, and a person may make an offer to sell narcotics but not have the means to sell either narcotics.
Not having the means.
Not have any drugs, for instance. He may be able to tell you that he wants to sell you 5 kilos of cocaine, but he doesn't have the means to do so.
So it's a fraudulent offer, essentially.
It's a fraudulent offer.
But didn't this Garber v. State, didn't the Texas Court of Appeals in Garber v. State say that a fraudulent offer to sell would not be within the state statute?
Correct. So going back to my earlier point that we were charged as ag felons, that charge was withdrawn by the government. Now the government comes before the court and tells you that even though they cannot charge me as an ag felon and they can make that charge that I'm an ag felon and I should be removed as an aggravated felon, that I'm not entitled to cancellation or removal because I've been convicted of an aggravated felony. What's the difference here? If I've been convicted of an aggravated felony, I should be removable as an ag felon. The government withdrew it because the government couldn't make it based on Fifth Circuit precedent. That's the reason why they withdrew the charge. Now, when the burden shifted and the burden came to me to prove that I was eligible for 248 cancellation or removal, they alleged that my client had been convicted of an ag felony. The same argument that should have been made in upholding the charge they so lodged against my client and later withdrew. There's no logic there. It's either good as an aggravated felony to keep me from getting cancellation or removal, and it's good enough to get me deported as an aggravated felon. You can't have it both ways. You can't say that this particular statute allows me not to be convicted, not to be removed as an ag felon, but it does not allow me to get the relief that I so seek before the court. There's absolutely no logic in that. And that's what they argued, and that's what the immigration judge looked at, and the immigration judge agreed. And then she went into the record of proceedings into the actual facts and became a fact finder and made a determination that my client had in fact been found and adjudicated guilty of an aggravated felony, in contradiction to what Hinkle clearly says and Mathis clearly says. Look beyond the elements of the statute, which she was not allowed to do. Can't have it both ways. I'm either an act felon for removal or I'm not.
All right, thank you, Mr. Millan. You've saved time for rebuttal.
I did. Thank you, Your Honor.
Okay, Mr. Beier.
Yes, Your Honor. May it please the court, Bryan Beier on behalf of the Attorney General. I regret not appearing in person at the court, and I appreciate the court's accommodating my participating by telephone today. Texas
Mr.
Health and
Beier.
Safety Code Section
Mr. Beier,
481.112
Beier,
is a categorical per se. Yes.
Mr. Beier, excuse me.
Yes.
Judge Barker has a question for you.
can you hear me, Mr. Beier? Mr. Beier,
Yes.
can you hear me?
Yes, I can.
This is Judge Barker. How do you respond to this court's ruling in United States versus Vickers that to commit an intentional offer to sell, a defendant need not have any drugs to sell or even intend to obtain the drugs he is purporting to sell?
Well, Your Honor, those points don't detract from the point that an offer to sell, when accompanied by an intent to complete the sale, is a substantial step in furtherance of a sale that is strongly corroborative of an intent to complete the sale.
Does the
Therefore,
state
qualifies as an attempt.
Does the state crime truly require an intent to complete the sale or merely an intent to offer a sale?
The element, as I understand the Texas cases, is that the offer has to be has to coincide with an intent to complete the sale.
Thank you.
Yes, I'm sorry.
Thank you.
Thank you. So the core issue in this case, as the court knows, is a question of federal statutory construction. Does the offer to sell a controlled substance, accompanied by an intent to complete the sale, constitute an attempted transfer for purposes of the Controlled Substances Act, and thus a drug trafficking crime aggravated felony? The agency correctly answered this question yes, and its decision should be affirmed. Now, we know that under Hinkle, Section 481.112 is not divisible as to the offense conduct. So if the answer to that question is no, offering to sell drugs is not punishable as an attempted transfer, then the statute is not an aggravated felony drug trafficking offense. Because we know that the Texas law does include such offers to sell. In that event, the court should go ahead and remand the case for the agency to address whether the crime is nonetheless an aggravated felony under the other possible ground, which is that it could be illicit trafficking in a controlled substance. The agency didn't address that issue, and it should be free to address it on remand if the court determines that the BIA erred. To address Mr.
Beier,
Yes.
Is it your position that you can prevail under existing Fifth Circuit published precedent, or is it your position that we would have to in some way change some of our existing case law in order for you to prevail?
Our view is that Fifth Circuit precedent does not resolve the question presented in this case. The Fifth Circuit precedent supports our position, but our view is that the court has not decided this question regarding the meaning of this aggravated felony classification. The court, many cases that address, similar issues like Vickers and Gonzalez and Morales-Martinez, those cases are all addressing sentencing guidelines or the ACCA that differ in ways that are significant here. Although the court has indicated that the classifications are very similar, nonetheless the classifications are different from the one at issue here because they do not incorporate the language of the CSA. And as the court observed during my friend's argument, the CSA includes the language attempted transfer. And that is critical to this case. That language is not in any of these sentencing guidelines. So the issue is open in our view. As the court knows from our brief, there is a bit of a bump in the road in the courts getting to that result, and that's the fact that the government in prior cases years ago conceded that based on Ninth Circuit precedent, offers to sell are not covered by the CSA and not drug trafficking crimes, aggravated felonies. The government has since reconsidered that position and now urges opposite. The BIA has set forth a cogent reason why that is the proper analysis. When the government conceded the issue, it did so on the basis of a Ninth Circuit case that did not faithfully apply the language of the CSA. What the court did was, in the Ninth Circuit, was that it said, it determined that offers to sell are solicitations, and solicitations can't be drug trafficking crimes. And so the court did not consider and address the question whether offers to sell could nonetheless be classified as attempted transfers. That was the problem with the Ninth Circuit's analysis. And the Martinez Third Circuit case, as I 28J'd in the letter on April 21st, explains very well that the problem with the Ninth Circuit's view is that offering to deliver a controlled substance does in some circumstances constitute an attempt, and the Ninth Circuit is wrong to just say that it never crosses the line between preparation and attempt. So our view, as I said, is that the court has not decided this issue. We conceded it in U.S. versus Ibarra-Luna, and as the court knows, that was a sentencing guideline case, and the issue was whether there was a harmless error. When the government has made that concession in that case and other cases, the court has decided the case in line with that concession, but it's never, in a published opinion, squarely examined and resolved whether that federal law question is actually correct. So in our view, the question remains open in this circuit. Now, if the court disagrees and concludes that it's not open, then it should apply its precedent. So I have two additional points as to why it is that the court should conclude that the issue is open. First, no judgment of this court actually forecloses the court from addressing it. Only a few cases even address the specific issue in the aggravated felony CSA context. And the first one, which was Vasquez-Martinez versus Holder, decided in 2009, held this Texas statute to be an aggravated felony, notwithstanding the offer to sell. Now, that case relied on circuit precedent that was later abrogated, but that abrogation didn't occur until 2016. Despite that, in 2010, the next year after Vasquez-Martinez was decided, the government made its concession in Ibarra-Luna. And the government also conceded that because of that, the district court's calculation of the guideline range at issue in that case was incorrect. In Ibarra-Luna, the court noted that concession and decided the case in accordance with it, but it didn't mention Vasquez-Martinez. It didn't address the substance of the issue. And then when later in Ibanez-Beltran versus Holder in 2017, the government conceded that an Arizona state solicitation statute is overbroad for the reasons that the government conceded overbreadth in Ibarra-Luna. The court again decided to issue the case in accordance with that concession, but didn't really address it. I also want to make the point that the fact that the government has previously asked the court to revisit this question of overbreadth of the Texas statute in sentencing cases, and that the court has declined to do so, doesn't establish that this issue isn't open. I mean, the question there arose in the sentencing guidelines context, whereas the court knows sentencing guidelines can be amended to resolve recurring issues. This question arises in the statutory context where we submit the court's precedent doesn't address it, and the court should be clear regarding the meaning of the statute. Just on the merits, the board in its decision in 2019, June 2019, which is the decision before the court, set forth very cogently the reasons why offers to sell with the requisite intent are just as punishable as CSA felonies as the other conduct within Section 481.112. I mean, the BIA determined that the question was open before them and explained how the Second Circuit in Pasquale versus Holder had reasoned that an offer to sell, when it's what the Pasquale court referred to as a bona fide offer to sell accompanied by intent, was both a substantial step and an overt act in the attempted sale of a controlled substance. And the BIA noted the Sixth Circuit in the sentencing guideline case came to used the same sort of reasoning, and the BIA said, well, we agree with those approaches. If the BIA had cited the Martinez case that I 28J'd the court, that would have further, underscored that it's appropriate to consider Section 481.112 a categorical drug trafficking crime. The BIA pointed out, with reference to specific Texas law, that the conduct necessary to prove that an offer to sell was made constitutes a substantial step in the attempted sale of a controlled substance, and for that reason qualifies as an aggravated felony.
Okay.
If the court has no questions, I'll just ask that the court deny the petition for review for the reasons stated in the brief of the argument here today.
Thank you, Mr. Beier, and we appreciate your participation. Mr. Millan, you saved time for rebuttal.
This case has been before this court for almost 6 years. It started back in 2015. It was remanded to the BIA by a panel of this court to allow them to look at the Fifth Circuit precedent and look at the decision in Hinkle, the United States versus Hinkle. They then render a decision contrary to the precedent in this circuit. So, based on this court's longstanding precedent, it has been this court's position that a state criminal conviction that has a broader definition than the federal statute cannot be found to mean that the appellant satisfied the elements of the federal statute. a non-fact-finding court or an entity like a sentencing judge, or perhaps an immigration judge, or maybe the BIA, should only inquire as to whether the appellant was convicted of an aggravated felony, not whether his acts constitute an aggravated felony, because they are not fact-finders in a criminal case. That's not their role. Ultimately, the government not only did it not remand the case and follow the instructions of this court, because they didn't look at Hinkle and they didn't base their decision based on Fifth Circuit precedent, which is the place where this immigration case arose and took place. Now, they're asking you to act as fact-finders and to essentially to find that an offer to sell is more and come to the conclusion that my client's conviction is in fact an aggravated felony. As I stated in the first portion of my argument, if it's good enough to be an act felony to keep me from getting relief, why isn't it good enough to get me deported for life? I have nothing further.
Thank you, Mr. Millan. Your case is under submission, and we especially appreciate your ability to come here all the way from El Paso. I hope you have a good trip. And again, thank you to Mr. Beier for his participation. The case is under submission, and the court is in recess until tomorrow at 9 o'clock.